record in its entirety. Accordingly, we ask that you summarize your testimony in approximately 5 minutes. And we're going to just move right down the line like we introduced you. We'll start with Professor Smith and go right down and finish with Mr. Wu. So, Mr. Smith, you're recognized for 5 minutes.
Thank you, Chairman Jordan, Ranking Member Plaskett. In the written testimony today, I explain at length why the convictions of Donald Trump in New York in May, because they relied in the end on alleged violations of Federal Election Campaign Act, or FECA, were incorrect as a matter of law, and I discuss some of the errors of law made by prosecutors and judges in the case. To quickly summarize, the payments that were made to Stormy Daniels were not under current law and should not be, as a matter of policy, treated as campaign expenditures, and thus Michael Cohen's brief fronting of the money, which was repaid to him shortly thereafter, does not constitute an illegal contribution. But moreover, the prosecution theory that the defendant, Trump, had to engage in a vast conspiracy because of a desperate desire to hide Stormy Daniels' allegations from the public and thus ignore campaign finance laws simply makes no sense, because even had they treated these as campaign expenditures, which again, I think they're correct not to do so, nothing would have come out before the election. As I explained, under the reporting schedules, nothing would have been reported until after the election, and the idea that illegality was needed is simply laughable. In fact, Donald Trump and the Trump for President campaign had plenty of cash to pay for the Daniels non-disclosure agreement as of October 27th, 2016. They did not need Michael Cohen to front them money for that purpose. Further, even assuming the expense was a campaign expenditure, no public disclosure of the expense would have been required until 20 days after the election. And repeatedly, the prosecution emphasized that the main desire of Trump was to hide this information until after the election. As a practical matter, then, having Michael Cohen front the money for the non-disclosure agreement between Mr. Trump and Stormy Daniels could have no influence on the 2016 election, despite the repeated claims by the prosecution that that was the core of the case. And this undercuts the entire theory of the case offered by the prosecution. This is explained in my written testimony. I'm happy to answer questions on that as we go forward. But right now, I just want to emphasize that this New York prosecution is something that is a very bad precedent. Let's just put it that way. Not only because it threatens the rule of law, and generally we have not in our defense of democracy, we have not been willing to shortchange procedures of law, but because it also threatens the bipartisan campaign enforcement system established by Congress. If allowed to stand, any state could do what New York has done, that is, pass a law making it a felony to try to influence an election by unlawful means. Then the state court could effectively try defendants for those alleged violations of FECA. Remember, in the Trump case, there was no finding by the Department of Justice that Trump had violated the law. Indeed, they decided not to pursue it. There was no finding by the Federal Election Commission that Trump had violated the law. They also decided not to pursue it. No federal body had found violations here. And effectively, the state was simply making up the law and enforcing federal law in a partisan, with elected judges, elected prosecutors, unlike the nonpartisan, bipartisan system set up by the Federal Election Campaign Act. And the members of this committee, and there are several who live in states that are dominated by the opposing party at a state level, might want to take heed of that possibility that this game can be played in many different ways. And one can run the risk of being prosecuted for violating FECA even though the FEC found no wrongdoing. It should be pointed out here that Judge Mershon, during the case, took great pains to make sure that the jury was not informed that neither the Department of Justice nor the Federal Election Commission had decided not to pursue allegations against Mr. Trump, but at the same time allowed in repeatedly statements by the prosecutors and by witness Michael Cohen stating that he had clearly violated the law, and there was no doubt about that, and thus implying that Mr. Trump had done so as well. It's worth noting in the end that it's right for this committee, I guess I would say this, it's right for this committee to take up this issue because it is a federal issue, not only of due process, but of that enforcement of the statute. And we could have a tremendous amount of chaos, and every federal campaign will be governed essentially by whatever one can get a state judge and a state jury to do. That's not how the Federal Election Campaign Act was set up, and that's not how this should be pursued. So I hope that this body will recognize that this is clearly a federal issue And not only are there major constitutional questions about due process, but again, it may even be something where some legislation is necessary to make sure that state prosecutors cannot try this again. Thank you.
Thank you, Professor. Mr. Fahey, you're recognized for 5 minutes.